Greetings. Thanks for joining me. My name is Steve. Look, getting a lot of people contacting me the last 2 weeks or so, talking to me about case preparation. What should they do? What information should they include in a case? You know, of course, this is family law. Some of the things I'm going to talk about, you need to research. But I guess let's get right into it, During case preparation, it's really important, first step, know your motion, or know, if you're the respondent, know what the proper paperwork to respond to the motion is. If it's a restraining order here in Washington State, oftentimes you file a motion to terminate, and then you got to follow all of that court's local, courtroom rules to the T. You're going to get smoked if you don't. You can't expect to go in there and just talk to the judge and say, well, this is why, and believe me, because I've made this mistake, this is why, and this is how, and this is who, and the judge is going to wash you out. If you don't file the appropriate paperwork at the appropriate time, the judge is going to wash you out. So I want to talk about, I want to see if I can turn this here. I want to talk to you guys a little bit about some of this, and I'm not sure if this is the right app. I've never used this app before to do this, so bear with me. But anyways, so on the day of court, when you get there, you're going to have trial or your hearing. And it's important that you know your case. It's important that you know what the other person has said. It may not be important to argue every little point that the other person brought up. Remember, in civil court, they need the preponderance of the evidence. In criminal court, the state needs 100% of the evidence. So what you're looking at here is a case where, he said, she said, don't give the judge, and I've made this mistake too, don't give the judge more than they need to go ahead and issue a restraining order. Stand there, be nice, be polite, yes, Your Honor, no, Your Honor, yes, ma'am, no, ma'am, that kind of thing. But you know what? It's important to tell you, know the motions, know their meanings, know the rebuttals, and practice your cases with somebody. None of us here are lawyers, or very few of us are. It's important to practice your cases. Get mom, dad, sister, cousin, aunt, brother, best friend. Me and my best friend, whom I call my brother Bill, we would go over my cases with a fine-tooth comb, 2-3 times a week sometimes. I would know every single document in my case. I would know, when it was filed. I mean, you name it. I know that case like the Bible. The colors of the rainbow, I know my case. I want to make sure that anything that the opposing party or the other party can come at me with, I have a response for it and a document to back it up. It was once said to me, what you have is great, but it's what you don't have that's going to screw you. And that person was absolutely right. And so, knowing your case today is going to make such a big difference tomorrow when you're in court. Because the judge could ask any number of things, any wild card thing the judge wants to throw at you. He can, and it might not even be something that it might be only a document that you've seen in your case once or twice, and he's going to go, okay, well, right here and right here it states this and that. Let's talk about it, and you're going to go, because you didn't practice your case. I cannot stress upon you guys enough that it's so important to practice your cases. When you're sitting there and you're handing the judge document and the judge says, well, what about this thing? Boom. That's how it went down, Your Honor. I went to this place and got this document from these people at this time. It's done. You've taken ammunition from the opposing party. The other thing is, it's important to know your judges, know your judicial officers, and not only the ones who have been sitting on your case, but the ones who could be sitting on your case. This is something that I had to figure out kind of by the School of Hard Knocks. I had to learn not only to research my judges or my commissioners, but also the entire line. So when I walk into court, I know whether it's Edward Harmon, Commissioner Dickey, Commissioner Johnson, retired Judge Johnson, whether it's Culpepper, whether it's Orlando or Elizabeth Martin. I ended up having to know a little something about every single judge that I had to see, or I could potentially have seen. And then I had to know something about how they run their court. And so how did I do that? I actually took time out of my unbusy life, apparently, because I just have all the time in the world to go blow on this kind of thing. But I end up having to go and sit in the court, on my off time, and watch how these judges rule on cases. Take notes. I sat there and wrote down, this judge likes this kind of thing. This commissioner likes this kind of thing. They all tend to kind of like this kind of thing. So I took very specific notes, and I paid attention to how, the lawyers, argued these cases. I paid attention to how the judges accepted those arguments and moved forward with those arguments. Watching, get some time in. When you're not a participant, you can sit back and watch how these judges, decide these cases. Or oftentimes, they'll put it over on a side of guardian ad litem, or but it's important for you to know how these judges are going to do this. You're going to walk in there and you're fighting not only for your life, but also for many of you guys, you're fighting for the lives of your children. And it's important to be armed with as much information as possible. If you're walking in there going like this, I'm just going to tell you how it is, nigga. I'm telling you what, you ain't getting your kids. Straight up, you're not getting your kids. Now, you walk in there, good morning, Your Honor. Here's my case. Let's get this started. Answer the judge's questions, answer her questions. If you rebut at the appropriate time for the appropriate reasons, and you're not cocky about it. And I know one time I was there, and I got cocky with this judge too. I think this guy was completely out of line. However, it didn't do me any favors. I learned a very valuable lesson. You can't yell at the judge. Was the judge wrong? Yeah. Was he being completely one-sided and obtuse? Yeah. But there was nothing I can do about it. At the end of the day, there was just nothing I could do about it. Anyway, so knowing your cases, that's important. Knowing your motions, that's important. Knowing what your motions do, knowing what they mean, that's important. A lot of you guys can go and pick up a paralegaling book for $10-20, Barnes & Noble right there, and you can start figuring out how to go about filing your motions, what your motions mean, what an interrogatory is. There's a number of things you can do to help yourself. Another one here, and I can't stress this enough, but I've seen and I've talked to enough people, it's so terrible too. Oh yeah, I've got my friend, my neighbor's going to come in and tell the judge that she saw the wife drive the car through the garage because she was mad. Okay, great. But is your neighbor going to come in there and be like, oh yeah, me and Steve drink beer every day and smoke pot? Okay? Know what your witnesses are going to say. Because her attorney, or even the state's attorney, depending on the nature of the case, he might get neighbor Bob in there and say, okay, Bob, how long have you and this guy known each other? Oh yeah, we've been great neighbors for 22 years. Okay, great neighbor Bob. You guys ever barbecue? Oh yeah, get together and have beer all the time. All that's doing is driving your case into the ground. Now we've got a witness on the stand who says that you abuse alcohol and you smoke pot. Not going to help your case, not going to do you any favors. So practice with your witnesses if you can. Interview with your witnesses. Know what the hell they're actually going to say when they're in court. It's important. I've seen cases go, and attorneys do the same thing. Oh, we've got this star witness, and this is what they're going to say, and this is how it's going to help our case, and da-da-da-da-da. And what ends up happening sometimes is quite the opposite, because the witness went in there and offered up too much information or not enough information, or you find out that they really didn't see what they said they saw because they're trying to be a cool neighbor and, just go with whatever you want. And at the end of the day, they're not going to give the court the information that the court's looking for. and potentially screw you. So knowing your witnesses is completely key in any one of these cases. You know, going back to your emotions, though, I can't stress enough. I have seen people, I've had people come to my house here with their cases, and they're literally like, I found all this. I found it all in court, and I lost. Okay, well, let's see what you filed. First of all, that's the wrong document. That's the wrong document. That's not the right document. You didn't file this correctly, and that's not even completed. So the judge kicked your case out of court, and the other person won because they did their homework and they did the correct thing. Hang on one second. You need to go play. So knowing your cases and knowing how exactly to file your documents, what your documents mean, filling them out correctly, dotting all your I's and crossing all your T's. These are important things that are going to help you in your civil case. Also, when you file your motion, make sure that you have the return of service. I've sat there in court, and I have seen cases, and it looked good. It looked great. Like, oh man, you had everything there. But here's the thing. Here's what you've done to yourself. If you don't do the return of service properly, you just go down and file your documents, but you don't have your RTS filed with the court, the other party gets a second chance to go over everything that you filed. Okay? So they're going to be able to come in there and say, yeah, but I wasn't served correctly. Give me that case. Then they're going to have more time to study that case and know all of your points probably before you do the next time you go in. If that happens, keep your case, refile it, get the RTS in place, or it filed in the court, and move forward, because, if you don't, you ain't going to have a case. I'm not going to sit here and talk about, what about public service? Look, I've heard Facebook, you can publicly serve somebody on Facebook. I've heard you can do it in a newspaper. I've heard, you got to go to your local court clerk and ask them what they accept. Oftentimes public service is incredibly expensive. You're probably better off finding aunt, uncle, friend, Ralph, somebody that will not be a party to the case, other than, I served Steve this document at this time, at this place, and then, file the RTS with the court. We're not going to get into expenses and stuff, because there again, it's up to the individual court and local courtroom rules, and how they do that in each specific county or district and whatnot. But another thing, and this is tough. This is tough for a lot of us. We're not here to bash the other party. We're here to present a case. And I'm telling you guys, and I have a hard time with it myself, but I can't stress upon you enough, you're just trying to present information. And the information will bash the other party. All you're doing is saying, here's the issue, here's what happened, here's the way it went down, here's my evidence that supports my side of the case, and let them go. Let the court, let the judge or the judicial officer go with it from there. I made a few mistakes in my case. One of them was not having enough written correspondence. So again, know your witness. A guardian ad litem can be your greatest witness and your worst enemy at the same time, in the same breath. So when you deal with the guardian ad litem, deal with them via correspondence. I'll have to do a whole nother video on that. But correspondence means you text message them, you email information to them, you make sure that you can document what they say. Oh, I'm sorry, I don't have enough time to talk right now. Text, send. Save that text. When they text you back, if they do, Your Honor, I don't have a lot of minutes on my phone, or whatever you got to say. But correspondence is key with these guardian ad litems. There's something else. Most of the time, I don't recommend a guardian ad litem in the case, and if I do, you're walking on ice. But every once in a while, though, there's a case that I hear about or somebody talks to me about, and I'm like, you know what? Based on layman's knowledge, which is what I have, I'm not a lawyer or anything like that, but I do have some experience in the family courts. Guardian ad litems, they can be good for you. They can. It's doable. You can't go into court, I should have wrote this down on my talking points today, but you can't go into court with your pants down. Research, hey, background checks. Anybody can do it. Go to your local police agency, your local county police agency, go to your state police agency, records requests. You can request CPS records, you can request medical records, you can request school records, you can request, the list goes on. You start compiling information and pulling information together and putting it in one place, you can get a picture of one of two things. Something's going very right with my children, or something's going very wrong with my children. Now, a lot of these agencies might say, well, why do you need this information? Well, I may want to present something to the court, but you can also play it off as, hey, I heard things are going great, I just want to see it for myself. Just because you're a non-custodial parent does not necessarily mean that you are not a parent. A lot of people that are granted custody seem to have this misnomer that they are the end-all, be-all with the children. That is actually a fallacy, and more courts are supporting the non-custodial father or the non-custodial mother, or we'll just say the non-custodial parent. More and more courts are getting hip to the idea that because you were granted custody, you think in your brain somewhere that you have the almighty powerful control of the child. And that is completely wrong. Most of the time. What I mean is, you still have rights to access school records. You still have rights to access medical records. Unless a court has taken that right from you, you still have that right. Ta-da! Hey, look, Mom, I went down to Johnny's doctor, and I saw that right here on this paper that you haven't taken Johnny to the doctor when he was sick 3 times. And so you had to have this, that, and the other. I have something to take to the judge because I think you're neglecting the kid. Okay? You can go to the school and, get school records. Now, this is a federal thing. So you can go to the school and be like, hey, look, I'm non-custodial father, blah, 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 blah. I want to know what Johnny Susie's doing in school. The school, unless actually notified by the court via a document that restricts your rights to information, which is pretty tough to do. A lot of you women may not understand that, but Dad has rights, and if Dad would learn how to exercise his rights, he can go in there. I don't care if you've got custody all day long. He can go in there and get all kinds of information. So all of this stuff he can put into this motion before he goes into court, and that's what I'm talking about today. You compile all this information. You know your case. You know exactly what you were going to say. Me and my brother Bill, we used to go over my case all the time. And, we'd sit here at the table even, and we'd jam it out and jam it out and jam it out and jam it out again. And then we'd go over it one more time. We'd make sure that, my motions were correct, that the paperwork was correct. Washington State courts, you go to Washington State courts, you can go and get your paperwork about 95% of the time. And so when you file that, the only trick there, when you file it from the state's webpage, is that you've got to make sure that it's it's conforming to the local courtroom rules. So whether that's Spokane County, Yakima County, and that's a whole other thing for legislators to take a look at. Personally, I think they should make it a blanket statement across the board. A form is a form, a rule is a rule, a law is a law, across the board in Washington State. Because what you end up having in 90% of cases is one or both parents end up, after time, moving out of said county eventually. And so we need to uniform our family courts from, Skagit County all the way down to Skamania County. From Port Angeles to Spokane. We need to unify our courts and our courtroom rules and our local courtroom rules. So, I think that would benefit lawyers as well, because, they would all kind of have the same mindset. It would make case law a whole lot easier, a whole bunch of other things. And I'm glad I said that. Case law is an interesting thing. It can help your case. Again, know your case. No case law that supports your case going either way. And it's completely okay to throw in little tidbits of evidence that supports your case. So, in any debate, you can go through a local newspaper or print out a story, as long as it's a viable, recognized news agency. Mother drives family van into river, kills 5 kids because she was mad at dad. Print it out, slide it in your case. It's completely legit. It's perfectly okay. Take a story like that, attach it to your case, and file it. You're showing the judge, in doing so, you're showing the judge that you have some idea of what the severest impact to your children can be by you not being allowed to be involved. Or you're showing the judge that mom is, that the mother in this case is in the same condition as the mother in that case, and so the two are going to tie together. Order of the courts are stare decisis. So anyways, it's important to, part of knowing your case is knowing case law. But for right now, I'm going to let you guys go. I look forward to your questions and comments. Peace out. We'll talk to you guys in a bit.